Susan. Ms. Mangum.
Good morning, Your Honor. May it please the Court. Paula Mangum for the defendant, Eric Morasse. This matters before the Court, having been transferred from the appeals court sua sponte. The issue in the appeal is whether time spent on home confinement with electronic monitoring, established as a condition of pretrial probation, comes within the meaning of confinement for the purposes of crediting a defendant against his committed sentence pursuant to Chapter 279, Section 33A.
Can I ask a fact question here? Thank you. I take it that your client consented to this as a term of pretrial probation, correct?
Yes, Your Honor.
All right. So this wasn't imposed. This was consented to.
Yes, yes.
All right. Secondly, I'm trying to understand the sequence here a little bit. It says on June 30th, 1999, the defendant's bail was reduced to $2,500 cash. On that day, bail was posted. And then on July 2nd, the defendant was returned to the Lawrence District Court and released under the pretrial probation statute. Is that correct?
Yes, Judge.
So he wasn't released when bail was posted. He was brought back to court, and there was another hearing?
He was, I believe there was another hearing because he was returned from Bridgewater and taken into district court with bail, and then I believe he came back for a subsequent hearing on the home confinement condition.
On the condition, the pretrial probation condition?
Yes.
Okay, thank you.
And just to briefly sketch that context, as I mentioned, the defendant, subsequent to his arrest and being charged in Lawrence District Court, was committed to Bridgewater State Hospital for 30 days under Chapter 123, Section 35. It was clear that there were mental health concerns throughout the time frame in this case.
Now, we have an appeals court case, do we not, that covers the point? Spite.
Well, Your Honor, Spite actually is Spite specifically says that these statutes don't apply because the issue in Spite was probation that was imposed after a sentence. So Spite says that initially the jail credit statutes, which deal with time before or during trial, don't apply in that case. And then Spite's analysis of the idea about whether an inpatient drug treatment program equal incarceration, the court in that case said no, it didn't. But the appeals court also recognized that there might be circumstances where a probation condition would be the equivalent of custody or incarceration, depending on the deprivation of liberty.
The test is really, since the statute itself is not clear on the point, the test is one of fairness, is it not?
Yes.
And isn't it eminently fair with regard to your client to not credit him with this time? Because he got quite a break here based on what he had done and his psychological condition and a few other things, not to be locked up or to be put under bail that he perhaps couldn't raise.
Well, Your Honor, my response to that is that because the jail credit this statute, 279 Section 33A, refers to time spent in confinement. And the idea about what confinement means is not more expressly limited than that. And the question then becomes whether this home confinement, which Your Honor is certainly correct that really is sort of a better bargain than other situations. But home confinement, whenever it may be offered or imposed, is certainly a better bargain than incarceration. And there are times when home confinement itself, for example, if it's imposed as a condition of prisoner classification, is still very much considered custody for the purposes of whether or not a defendant's held in custody. So I think the question is more in terms of fairness and fair treatment, whether or not the deprivation of liberty in this case was sufficient enough for the confinement to qualify.
If we agreed with you, then, I mean, there are various types of restrictions that get placed on people who are put on pretrial probation that restrict their movements, where they can and can't go, where they have to be during certain hours. if we agree with you, aren't we going to be drawn into drawing these kinds of lines or hearing arguments of, well, because I had a curfew and had to be home between the hours of, 9 o'clock p.m. and 6 a.m., I should get, a half day's credit because I was confined for half a day every day. Analysis of whether a particular set of restrictions on a defendant's movement and location amount to confinement. Is that what the legislature really meant us to be doing here?
Your Honor, I think that is a concern, that whether or not there would want to have to end up being this case-by-case analysis as you suggest, and that the defendant is here before the court asking that in this case, under his circumstances, that his confinement qualify. What the answer to that is coming forward, I think, is a more difficult question. And this is certainly an issue that's being confronted in jurisdiction by jurisdiction as, of course, home confinement with electric monitoring becomes more and more prevalent. And I can tell the court that that the jurisdictions that have allowed credit for home confinement, and particularly with electronic monitoring, that I have been able to find indicate that, certainly the one that's most comparable, I would suggest, is Washington, where their statute specifically says that they allow credit for all confinement time served before sentencing. It does say all confinement time, but I would suggest that our statute is not necessarily more limited than that, in that it does say confinement, days in confinement.
Can you shed light? When was Section 33A, or this wording in Section 33A, adopted, and how does that compare to when the first onset, if you will, of the use of electronic monitoring? Because I think electronic monitoring is a relatively recent
Yes, Judge. And 33A was implemented it was adopted in 1955.
Yeah. So
and
long
then
before we had home confinement or electronic monitoring.
Yes, yes. And the corollary chapter 127, Section 129B, which is addressed to correction, is not adopted at the same time, nor is the language identical, which partly adds to, I think, the little bit of the argument on my client's case. That was enacted in 1960. So you're absolutely correct that that the statute didn't contemplate that. But as other jurisdictions, this is one of the reasons I think other jurisdictions are struggling with the issue, because they're dealing with statutes that didn't contemplate this home confinement with electronic monitoring, and therefore jurisdictions have gone sort of a variety of ways, including some where the legislature has specifically enacted a statute that says home confinement doesn't count. We are excluding that. Other jurisdictions, as I said, Washington, for example, has said because their statute says all confinement, whether total or partial, we're going to include it there.
So does it boil down to how we define the word confinement?
Yes, Your Honor.
Well, defines how you define in confinement.
I think it's the definition, sort of the conflation of confinement versus in custody. And that's why I suggest in my brief that the whole idea, and looking to sort of some of the other legal contexts we have in the Commonwealth, those terms can be sort of general or more confining, as it were, more limiting, depending on the context.
Well, hypothetically, would you say that Martha Stewart was in confinement when she was on the electronic bracelet? You'd have to say yes,
that would be after
you?
she was released from custody, yes.
In our case, were there any limitations placed on the defendant in terms of who could visit him in his home?
No, Your Honor, not limitations on who could come to his home. The limitations for him were being confined to his father's home. And then it appears on the record that the exceptions that were made was that his bracelet was removed for the purposes of obtaining an MRI, and there was also a period of time, I believe a period of time in which he was in a drug treatment day program. But
is there any evidence that the defendant sought to work and was unable to work?
No.
So that's a little unlike those cases where somebody, has sought to work.
And is permitted to go to and from work.
Well, if somebody has sought to work and is not permitted to go to work, that might be a different case. But
yes, there's no indication that he sought.
Could I ask you, Peter, assume he had violated this and, and had left the home and, gone out to, where he pleased. That would it not be treated as a violation of one of his probationary conditions, correct?
Yes, Judge.
Okay. it would not have been chargeable as escape.
Correct.
Okay. Whereas, had he been held in the jail, awaiting trial, and gotten out, that would be the crime of escape, right?
Absolutely.
Okay. I mean, there's a big difference. There's a lot of differences between being in jail and being in home.
I recognize that, Your Honor, and in fact, that distinction is one that other jurisdictions make, specifically there. Again, I would argue that the reason that distinction becomes a little bit less clear in our case is that there are situations in which someone can be outside, not this one, this is pretrial probation, but at the same time, someone can be outside, at least according to a ruling by the appeals court, can be outside the physical confines of an institution and still be chargeable with escape. So that makes it, not as crystal clear.
Oh, because
when someone is in home confinement or was in home confinement, were any of the credits, statutory credits that used to be given or may still be given in some cases, available to the defendant?
I'm sorry, Your Honor, I don't
The
think
statutory credits such as good time or program, any other program credits?
Though, once again, for the purposes of good time credits, I think that the appeals court has suggested that those aren't available for that.
So wouldn't that lead us to the result that this is different from confinement in an institution?
Although, again, I think that would be in the case of, I'm sorry, that actually is DuPont. And that is a case where it wasn't pretrial. The only time that the denial of good time credits has been addressed was in the context of the idea of the prisoner being outside the institution in a different facility. And for the purposes of the denial of good time credits there, when the defendant reoffended, in that case, the appeals court said, you're in custody when you are in custody when you're outside the confines of the institution, and therefore we deny you good time
Because he'd been
credits.
committed to the custody of the department.
Corrections.
Your client was not committed to anybody's custody.
He was not committed to anybody's
He was
custody.
just on pretrial probation. This happened to be one of his conditions.
Correct. At the same time, home confinement with electronic monitoring, if imposed by corrections as a component of prisoner classification, for example, and then a prisoner walked away from his home, then he would be charged with escape. So we have the same context.
But isn't that because he has been sentenced to the custody of the state institution, which can then make various decisions about what freedoms he will get?
Yes, that is the
And
distinction.
your client was on pretrial probation, is that right?
That's correct.
And don't we have cases that say probation is not a sentence?
We have,
And so what would we do with those cases? Because the credit that you're trying to get for him goes to a sentenced person.
the cases that deal with probation are dealing with probation imposed after a committed sentence. The defendant's argument is that this is a distinct animal because it's this pretrial probation that is the mechanism that this Court has said, the statutory mechanism whereby, one of the three, I believe, whereby a judge can impose conditions prior to a trial. And so it's the idea that that probation, time spent on probation doesn't count as a credit when it's probation subsequent to the sentence.
Okay, but your client is on pretrial probation, and he may well be acquitted. In fact, the presumption of innocence is that he's not guilty. So how can we give him credit for for credits that were intended by the legislature for somebody who's sentenced, who's already been convicted, when your client may in fact be acquitted?
Well, if he were acquitted, of course, there would be no issue of credits. And the case law has said it's...
How does that make sense, then? How does your position make sense? If he may be acquitted, he's certainly not entitled to what a sentenced person gets. And so he shouldn't be entitled to what a sentenced person gets in any event, because he isn't a sentenced person.
That's the same as if the defendant is held in custody, I mean, in a house of correction and is acquitted, he doesn't get the credits, correct?
Yes, I mean, that would be the analysis.
I mean, that's the difference between 127, Chapter 127, Section 129B, and Chapter 279 and Section 33A.
Yes.
One says the sentence of any prisoner, and the other is the court on imposing a sentence of commitment.
Yes, and furthermore, Justice Cowan, I would point out as well that this is not a situation where if he were acquitted, for example, that he could be banking this time against another offense, because the cases have specifically said that that's not permissible. But that's not what's going on here. He's not trying to bank this time against another offense with which he may be charged, or that he has been charged.
Your case stands or falls on the wording "in confinement prior to such sentence awaiting," correct?
I agree, Your Honor.
Under Chapter 279, Section 33A.
Yes.
So it's not he's confined in some way, as Justice Sussman was suggesting, or he has some conditions imposed. He has to be in confinement.
It stands on the issue of what confinement means and how broad or narrow is that construed under.
Well, in means that you, the very least is we have to read in as you are confined to a particular place. It's not some other condition of pretrial probation, correct?
Yes, Your Honor, and I think in a confinement traditionally would be defined as confined within some place or boundary or somehow limited, but the issue from the defendant's perspective is it doesn't necessarily say that it has to be an institutional setting.
Thank you, Ms. Mangum.
Thank you.
Slingerland?
May it please the Court, Marcia Slingerland for the Commonwealth. I think the Court has recognized the critical difference here, and the bottom line is the fact that the defendant was placed on pretrial conditions to which he agreed.
Well, let's take a step back from that. I see that as an interesting distinction, but under 59A, of course, the Court can impose significant conditions of release.
Under 59A?
59A, the bail statute, the bail statute relating to dangerous persons, for example. So my question to you is, can conditions of release ever be in confinement for purposes of Section 33A?
Despite courts suggest that there may be some circumstances in which a condition of probation might be the equivalent of incarceration, but they said
how could, I mean, confinement, perhaps if, I mean, I think the case law is if you're confined to Bridgewater, for example.
The statute clearly gives you credit.
Absolutely. So the legislature's dealt with that. So I was actually trying to think of what is the appeals court thinking of when it says that? I mean, it may just be providing some little, but this is 24-hour confinement to a home, correct?
Well, the record says he's on an he is to be placed on the bracelet. It appears that a lot of discretion was perhaps left up to probation. It doesn't even say confined to a home, at least on the record here. It says he's to be placed on the bracelet. I believe that, I looked at the probation file because I was unclear as to exactly what that meant.
Well, certainly you would agree with me that if he's on an electronic bracelet and can move around, he cannot possibly be in confinement, correct?
I absolutely agree.
I mean, and you would have to have a real reach, and as Justice Sussman suggested, if the statute was passed long before electronic bracelets. But assuming that one is confined to a home, yours or somebody else's, the defendant's or somebody else's, and can't leave.
I think...
And may have an electronic bracelet because there are very good reasons why you may want to make sure that that's where the person is.
Right.
With a satellite tracking device and everything else.
I think it depends on the person how they're being monitored. For example, when you're on pretrial probation, the probation department, as they did here, could go back into court and request that the bracelet be removed so the defendant could have an MRI. Or
what I'm saying is, assuming that the conditions of probation are, the pretrial conditions of probation are, he will not leave the confines of his house, his father's house, somebody's house. So he is confined to a place.
I would suggest that is not going to count. Is not going to count against the sentence unless it is imposed pursuant to, unless the Commissioner of Corrections, who has custody of that person, says, you know what, you're an okay person, I trust you, we have overcrowding, we're going to put you in your home. That will count against your sentence because the Commissioner of Corrections says you can go there. That person is still subject to being recalled at any time. They really don't have the freedom that they do on pretrial probation because the Commissioner of Corrections has control of that person. So I would suggest that's the distinguishing feature.
All right, what about this? Under 59A, 276-59A, the court can impose conditions of release, including...
For dangerousness.
Correct. Correct, for dangerousness, but that's conditions of release.
Correct.
And can require that a person remain in an institution, for example, a private locked ward at McLean Hospital or some other private hospital in a locked setting. Is there ever a case where that could be in confinement?
I have to say I had not considered that because I was just looking at what was occurring in this case. And I would be reluctant to go out on a limb to say when you're dealing with dangerousness, which you're not, there was not a finding of that here.
Well, dangerous, my question was provoked in part by Justice Cordy's inquiry, which is, in a dangerousness hearing, a judge may say the person is not mentally unstable, so it's not McLean Hospital, it's a home, an apartment, 24 hours a day with an electronic, can't go out, can't work, can't visit family, can't visit grandchildren. Maybe that's the next case. That's not this case.
As I recall, 58A, you hold somebody not based on their inability to return to court, but because they're dangerous.
Yes, and a judge may say, you are pretty dangerous, and so I'm going to make sure that, you stay at home.
Again, those are pretrial conditions and subject to, that can always be modified, and they are not pursuant to a sentence monitored by the commissions.
Yeah, but the problem with 33A is it's not pursuant to a sentence because it's when the court imposes a sentence. So that it's not the person who has already been convicted. That's 129B, that's 127, 129B. You're talking about the sentence of any prisoner.
When it's imposed.
Maybe that's just the next case. Maybe when you have pretrial probation of this kind, where there's not a dangerousness, and where at best the record is unclear, at worst it suggests that with an electronic bracelet, unless it said he has to stay 24 hours a day in his father's home, it doesn't constitute confinement.
I guess that would be my position at this point. I would note that this court in the Cowan case considered the subject of electronic monitoring and whether that could count toward a mandatory jail sentence for, I think it was a carrying a firearm conviction. And this court did note that living in one's home and being permitted to go to work, attend counseling, and church is not the same as being imprisoned in a jail or house of correction. And I guess I would return to Justice Sosman's expressed concern that, if you're going to go on a case-by-case basis, it's going to be difficult to do. But there can be a line drawn, at least with respect to this case, when you have conditions imposed pursuant to Section 87, whether you're released on bail with conditions or whether you are sentenced pursuant to the court's sentencing power.
Thank you, Ms. England.
Thank you. Unless there's no further questions, I'll rest on the Commonwealth's brief.